Romero, are you there at the main jail?
I'm here, Judge.
Okay.
Romero is here.
I'm sorry, what?
Romero is here.
Okay, very good. Did I say your name wrong?
They're just giving me a hard time. That's
Okay,
all.
I guess it's a Friday afternoon. They're allowed to do that. All right, we're back on the record for the afternoon docket for first appearances. First person on our list is Tamara Powers. Where is Miss Powers? North Broward, thank you. All right, we're switching to Miss Powers. Good morning. Good afternoon, Miss Powers. I have two matters here before me. You appear to have some capiases, both of them carrying a $100 bond. One's for an open container and one's for no lodging on city-owned property. Are you interested in resolving these matters here today?
Yes, please.
Okay. Does she have a background?
Yes, Your Honor, she does. 1 second. She was arrested in March of this year for DWLS. January of this year for carrying an open container.
Okay.
Last year, possession of drug paraphernalia and a trespass.
Nothing violent?
No, Your Honor.
All right, ma'am, I'm inclined to resolve this matter if you'd like to today to an adjudication time served on both of these. Are you interested in accepting that offer?
Yes, please.
All right, raise your right hand, please. Do you solemnly swear from testimony you're about to give is the truth?
Yes.
All right, thank you. You can place your hand down. You understand that you have a right to have an attorney represent you in this in all hearings. You have a right to have a trial. You have a right to force the state to bring witnesses to prove these allegations that they've made against you. You're giving up all these rights today in order to resolve your matters and plead no contest. Do you understand your rights?
Yes, I do.
You're giving up your rights?
Yes.
Is anyone forcing you or threatening you in any way to plead no contest here today?
No.
All right, I'm going to go ahead then and accept your no contest plea as being freely and voluntarily entered. I'm going to adjudicate you guilty on both of these cases. I am going to sentence you to the time served that you've already experienced and give you 1 year to pay any court costs associated with these cases. Good luck to you, ma'am.
Thank you very much.
You're welcome. All right, next we have Priscilla De Silva. Where is Ms. De Silva?
Judge, I've been informed she bonded.
Thank you so much. I had an opportunity to review her paperwork. I find probable cause. Jasmine Donaldson, back to North Broward, thank you. Miss Donaldson, good afternoon, ma'am.
She's not here yet, Your Honor.
She's not here?
This is Jackson. Donaldson's not here yet.
Okay, I'll go ahead and take care of Miss Jackson, thank you. Miss Jackson, hello.
Hi, good afternoon.
Good afternoon. I have 3 counts that are pending with you right now. The first one is a possession of cannabis. The second one is a resisting officer without violence. And the third one, a little more serious, tampering with evidence. At least that's a felony charge. The first 2 charges we have here are it's not necessary for you to post a bond. However, count 3 carries with it a $1,000 bond. Mr. Reedy, anything on behalf of your client?
Yes, Your Honor. Ms. Jackson's lived here all of her life, and she has extensive family here, including her mother. She has a 7-year-old daughter. She's currently in technical school, studying to become a licensed practical nurse. She's not working right now because she was in a car accident recently and was injured and suffers from pain in her neck, which was damaged in the accident. I don't believe she has any kind of extensive criminal history. She's provided me with the phone number of her mother, who I will call if need be to bond her out. I was wondering if the court would consider pretrial release, and I would also add that count 2 and count 3 seem to be duplicitous. I'd argue that there's no probable cause on count 2. It appears the resisting arrest or obstruction of justice was throwing the marijuana cigarette allegedly out of the window, which is also the tampering with evidence. So it seems as though even though there's no bond necessary on count 2, that she's being charged twice for this exact same act.
Charged in the alternative, possibly. Okay, I see your point. And it doesn't appear that there's any other evidence contained within the probable cause affidavit as to the resisting without violence. What's her background? And then I'll talk about the
The only thing I saw was a 09 resisting without violence.
2004 fraud. She subsequently received a withhold. She fails to repair due to dependency of back pain.
And I'm sorry, what part?
She fails to repair. 2004, Jacksonville. It was a fraud.
Okay.
Insufficient obtaining property by fraud.
And ma'am, this Hollywood address on Taft Street is your actual address?
No, ma'am, that's an old address.
Okay. What's your actual address? Is it the 4700 Southwest 36th Street? On your
No, ma'am,
36th Street? I'm sorry, go ahead. Tell me what your address is. Sorry.
the address is 4160 Northwest 21st Street in
40
Lauderhill,
4160
Northwest 21st Street,
in
Lauderhill, Florida, 33313.
And who do you live with?
It's currently my sister, my daughter, and her 2 children there.
And do you have a phone number for your sister?
It's 754-367-4218.
What's your sister's name?
Her name is Charity Jackson.
Are you interested in some sort of pretrial release, ma'am? I was considering something else, but given that you back over 10 years ago, you did not show up for one court date. Are you willing to participate in our pretrial release program?
Yes, ma'am.
You understand that any participation in a pretrial release program would require you to submit to random drug screens.
Yes, ma'am.
You're willing to do that in the future?
Yes, ma'am.
Okay. Remind me again, can I just do it without pending?
Yes, you can. The court can release her outright. She must report to pretrial on Monday between 8 and noon.
All right, ma'am, this is what I'm going to do. We've got your address on file. You're going to have to, I'm going to go ahead and grant your attorney's request to reconsider the bond amount. And I'm going to put you on what's called pretrial release. It's basically supervision ahead of time. They're going to release you, and on Monday, they'll give you the instructions. You need to go to the pretrial office and register everything, make sure they have your address and all, and as long as you can comply with the conditions of pretrial release, we won't have a problem. And then the case will run through its natural course, all right?
Okay, thank you so much.
All right, stay out of trouble and no drug use while you're out on pretrial. You understand that?
Yes, ma'am.
All right, good luck to you, ma'am.
Good luck, Barbara.
Thank you so much.
Your Honor, Donaldson Jasmine
Okay.
is at the courthouse.
She's at the courthouse?
Yes.
Who is this?
Miss Jasmine Donaldson. Okay, so I guess I need to reset her. She's on the regular docket at North Broward. So I'm resetting. And she'll be brought back when? Tomorrow or next week?
No, Judge, you don't need to reset it.
I don't.
No. She was county sentenced to date on that misdemeanor deal.
But does she has violation? She has capiases on felony.
You're not the magistrate. Those count
Okay,
2,
so
3,
I.
and 4.
Okay.
Yeah.
So I just do nothing then?
Yeah, no action.
No action. All right. All right, then moving on to Amber Hamilton.
Medical reset.
Do you want to address or should we just wait till she comes back? She's out on bond.
Who is?
Amber Hamilton.
She's been released. She bonded out?
No, she's on medical.
Okay, I'm just listing it as a medical reset.
Yes.
Okay. Oh no, my pen's running out.
Let me have that one so I can just put it in.
Yeah, I have another one. All right, next we have Jennifer Flagg Williams.
Ms. Flagg Williams is here, present judge of Maine. She is approaching.
Thank you so much. Hello, Ms. Williams. I have two charges here pending with you, of possession of cannabis and possession of a controlled substance without a prescription. The second charge carries with it a $1,000 bond. Ms. Romero, anything on behalf of your client?
Yes, Judge. In speaking with Ms. Flagg Williams, she's been residing in our community her whole entire life. She's 30 years old. She's currently employed. She worked for a teleperformance company. She's been working there for about 2 years, making $10.50 an hour. She lives in Deerfield with her father and her 2 children, ages 5 and 3. She's a single mother. Judge, from what she's advising me, this is her first arrest ever. She's a registered voter here in Broward County. The only person that could potentially post her bond is her father, but from what she advised me, right now her father isn't working, so right now he really has no sort of money
Oh, wait, stop. She's already been bonded? Her mother's already contacted a bondsman. No?
I guess you're
That's what her mother told us.
She said she would contact my boss man if I wasn't able to be released on
Judge, my understanding is her mom's probably going to do her best effort to contact the bondsman to see how much it is.
Okay, hang on.
It's already been posted.
Okay, hang on. Patrice was telling me something else. What? Okay, so you all are expecting an ROR? That's what her mother is indicating to Patrice. Okay. Are you sure she's never been arrested before? I see a petty theft here from 2015.
I did look that up.
She told me she never physically got arrested. She got her citation for the petty theft. I'm assuming.
Okay.
Okay.
Anything else?
Judge? Yes, one other thing. I know, from what I can understand, Judge, I believe in reviewing the probable cause affidavit, it's, from all indications, she gave consent, so she was cooperative with the police officer, so I'd ask you to take that also into account.
Other than these tickets here, does she have anything else?
No, Your Honor, I didn't see anything else.
Nothing else.
All right, ma'am, just in the future, you should never make those kinds of expectations that you're gonna get an ROR. I appreciate you all seem to think that. I'll go ahead and give it to you at this time, but you need to make sure that you come to court when you're told to come to court. Good luck to you. Timothy Odom, sorry, Mr. Odom. Where is he?
Mr. Odom is here present at Maine, Judge.
Mr. Odom, good afternoon. If I'm reading this probable cause affidavit correctly, it appears that you self-surrendered to a police officer, which I'm appreciative of. It also appears that this was a matter regarding pedestrian obstructing traffic. If you're interested in resolving this matter here today, I'm happy to do that if you promise me you'll stay out of the street.
Yes, ma'am. I'll stay on the median from now on.
Okay, there you go. Please raise your right hand. Other one, do you solemnly swear a firm testimony you're about to give today is the truth?
Yes, Your Honor.
All right, please, you can put your hand down. You understand that you have a right to have an attorney represent you. You have a right to have a trial in this matter, that you're giving up your right to a trial to have the witnesses brought to prove that you were in the street when you shouldn't have been. Do you understand you're giving up all those rights, sir?
Yes, ma'am. Yes, yes, ma'am.
All right, and is anyone forcing you or threatening you to plead out your case here today?
No.
All right, I'm going to go ahead and find that your plea of no contest here today is voluntarily entered. I'm going to go ahead and adjudicate you guilty at this time, sentence you to time served, and give you 1 year to pay any court costs associated with this matter. Good luck to you, sir.
If those court costs, I'm homeless, and if those court costs are not paid in a year, will they issue a warrant for me?
No, I don't think they can do that. They don't do that. There you go to a judgment, sir.
Okay.
Okay, but, you know, we appreciate trying to pay some of it. It costs us all money to have the court system running, so I'll give you a year to do it, all right?
Thank you, Your Honor.
All right, take care. Good luck to you.
Thank you.
Okay. Caleb Johnson.
Mr. Caleb Johnson, come on up, please. He's approaching, Judge.
Thank you. Mr. Johnson, you have a loitering and prowling charge that carries with it a $25 bond. Can you make your bond?
Yes, ma'am.
Okay, I'm gonna find probable cause at this time, and the case will process through the system. Good luck to you. Mr. Bishop,
Mr. Bishop, come on up, please.
same scenario, same golf cart. You have a $25 bond. Can you make your $25 bond?
Yes, ma'am.
All right, very good. Good luck to you, sir. I find probable cause. Mr. Neal, sorry, Mr. Fernandez. Yes, Mr. Fernandez, sorry. Good afternoon, Mr. Fernandez. I have a charge for you of carrying a concealed firearm, and it appears you may or may not have had a total of 17, 18. They're claiming you were also in possession of 18 ammunition by a convicted felon. So is count 1 carrying a concealed firearm by a convicted felon as well? Or just carrying a concealed firearm? And the rest is by a convicted felon?
Seen carry concealed firearm.
Okay.
What we generally do, Judge, if you're inclined to find probable cause, as to the carrying concealed firearm, possession of the weapon, which would be the gun, count 3, possession of the weapon, which would be ammo, you could find probable cause on the remainder of the charges and release him, or just release him on, I guess, not release him on his own recognizance. You could find probable cause, but not require a bond be posted on counts 4 through 19, since what they did is charge him for every bullet that he had, allegedly.
Okay. Isn't there any case, is there case law, something about not being able to charge for each individual bullet or something?
Ultimately, when it goes to the state attorney's office, I have a feeling that that's exactly what will happen.
Okay. In the meantime, I would like to know Mr. Fernandez's background in order to make a determination as if I'm willing to do what you're suggesting I do. What's his background?
Your Honor, the 2 cases that make him a convicted felon are both carry concealed firearm. One's from 01, one's from 2012. I see an 01 DUI, and then he has this case before Your Honor.
Mr. Romero, your client's ability to post a bond?
Not much, Judge. He's been here for about 20 years here in South Florida. He's 41 years old. He works part-time for a company called Marble and Tile. He's been working there for about 1 year, making $10 an hour. He rents a studio in Fort Lauderdale. He lives there with his 16-year-old son. His portion of the rent is about $400 per month. He shares responsibility with that child's mother. Judge, right now, from what he informed me, he has really no money in the bank, no sort of assets or anything like that. So we'd ask you to take that into consideration in determining a reasonable bond for Mr. Fernandez.
What's the state's recommendation on a bond amount?
Honor, as this is the 3rd carry concealed firearm, state would be asking for a $5K bond on count 1. Additionally, on the possession of a weapon or ammo by a convicted felon, we'd ask for an additional $5K bond.
On each count or just one of
Just
them?
we'd be fine if Your Honor wanted to split the amount up across all the counts, or just do $5K on the first count of ammo, and I guess on the rest ROR him.
Mr. Fernandez, I have a problem here. This appears to be at least from a history perspective, you're not permitted to have a firearm based on your conviction. So we've got an issue here that you don't seem to be able to comprehend, especially since the weapon that you have alleged to have in your possession was also loaded. I'm going to accept the state's recommendation of $5,000 and increase on count number 1. And $3,000 on one of the ammo, count number 2, and 0 requirement on the rest of the bonds. Do I have to put ROR, or can I just leave 0?
No, you have to say RR because they're holding.
Okay, so the rest will be.
All these, on all these. So it's only 2 bonds. It's 8,000, so 10%, $800. You understand?
And no more firearms in your possession. That's a condition of your release. Is you're not to have any firearms. If you have any firearms, they need to be turned in. Okay? All right, good luck to you, sir. Roman,
3 through 19 for the record is RR.
yes, ma'am. Roman Lennon?
Mr. Lennon? Mr. Lennon, come on up here, please. Huh? Oh, hold on one moment, Judge.
Okay.
Mr. Lennon was all the way in back, Judge.
Okay, Mr. Lennon, I see that you have a possession of cocaine charge as well as a drug paraphernalia charge. I've reviewed the probable cause affidavit. I do find probable cause. Mr. Romero, anything on behalf of your client regarding the $1,000 bond?
Can't hear you, Hector.
Your mic is off.
Oh, Judge, he's not going to be able to afford that. From what he advised me, he's homeless at this current time. He's been homeless, unfortunately, for the past year and 5 months. He's fell on hard times. He's 42 years old. There's no way he can afford any sort of monetary bond. What we'd be asking you to consider, Judge, considering this is a non-violent offense, I'd ask you maybe to consider releasing him on standard pretrial. Though he doesn't have a residence, that wouldn't preclude him from being on pretrial. If you tell him to go ahead and report once a month, he would have to abide by that. So that's what we'd be asking for at this time, Judge.
My problem is going to be, it looks like he has a couple of open cases. Granted that they're non-violent also in nature, but he appears to, he has several open 2017 case numbers at this juncture. He has one of them being an aggressive panhandling in Hollywood. That's open. He just finished closing out of aggressive panhandling in Hollywood. Some open
He's telling me,
container.
though, at least if it can show in the system, he's been going to court for that.
I don't know. I have to look. But he also has some open containers, some drinking alcohol beverage in public. He happens to have a status hearing on the 14th in one of his cases, but his mail came back, so they'll probably just reset that one.
Judge, from what he's also telling me, he's been taking a proactive approach. He's been contacting the clerk's office to find out his future court date. So it's not like he's basically forgetting about it or trying away from him. He's actually being responsible, trying to keep up with his court dates. He's going to do that with this case as well, and that's one of the reasons we're asking you to consider.
So if that's the case, what are the 2 court dates he has next week?
We're going to 14.
What about the other one? There's another one next week.
I'm sure on the 14th you'll probably find out when's the next court date.
It's the 11th on a different matter. So he has one on the 11th. He has one on the 14th.
So he has one this Monday.
Yes, that he's not going to be able to make if he's in custody.
Is that at Satellite or where's that going to be at?
It's at Satellite. And he has a 2015 possession of cocaine case that it looks like he fled out after a violation of probation at the beginning of this year. What's the state's position on me lowering his bond or releasing him?
Some pretrial release, Your Honor, or something to make sure, because he's got these other cases to deal with. I just don't want to see him, out and picking up K pieces.
Can he be required to report to your offices at a particular time, or report once a week kind of thing?
Absolutely, I believe he can.
Wait, she's trying to explain it to me. Go ahead, I'm sorry. But if he's homeless, then the responsibility is all on him to report to you. I'll give him a try. I'll give him a chance. He does have court next week. If he doesn't show up on those, he's going to end up with capiouses. So he
Jeff,
has
can
a.
you tell me, so I can write it down for him while we have that information up? Which court room and the particulars on the 11th?
All right, let's see. He's going to be at South Satellite on the 11th, which is Monday at 1:30 in the afternoon.
That's the one in Hollywood, correct?
Yes, sir.
At what time?
1:30.
Do you know the room number?
230. He knows it.
Okay.
So this is where you get, yeah, I know that.
Perfect.
And then he also happens to have a hearing on the 14th that if he tells them on the 11th about the one for the 14th, they might be able to take care of that one for him as well. It's the same judge that's assigned to the case.
Okay, so let the judge know on the 11th that you're court on the 14th to see if maybe they can go ahead and address it at that time. And you also have to report to pretrial. Judge, I'm assuming by the time he gets released. Oh no, sorry, you're gonna ROR him, correct?
I'm going to put him on pretrial release.
Yeah. By the time he gets released today, pretrial is going to be closed, so he would have to report to pretrial before 12 noon on Monday.
And to still make it to his court hearing out at Satellite at 1:30. So he's going to have to be waiting for pretrial release to open their doors on Monday morning.
Yes, Judge. I'll let him know.
And you have to come, and you're going to set up a schedule with pretrial release. You have to report once a week to pretrial release. You miss one day, and they're issuing a capious for your arrest. You understand that, sir?
Yes, sir.
Okay.
What time does pretrial open their doors on Monday? 8 in the morning or 8:30?
7:30? 7:30 a.m.
7:30 a.m.
All right.
Thank you, Judge.
All right, sir. Don't make me regret doing this. Okay. Michael O'Brien.
Michael O'Brien, come on up, please. Judge, he's approaching and he declined the service of public defender.
Okay, Mr. O'Brien, good afternoon. I don't know if that anyone's really going to be able to change much this afternoon anyway. You do have
Something
a right
can
to
be
have
changed.
You have a right to have an attorney represent you at this and all hearings, and if you cannot afford an attorney, I could look into the possibility of appointing a lawyer to represent you. You have declined the services of the public defender, so I need to find out from you if you want to represent yourself at this time, or if you want me to reset this matter so you could hire your own attorney. You have 2 no-bond holds right now on violations of probation and/or community control. You're already scheduled with your division judge on your felony charges for the 13th of December, which is Wednesday, at 8:45 in the morning. And then you have 4 misdemeanor cases that you have bonds on, those bonds being $500, $500, $500, and $2,000. For a total of $3,500. Do you want to go forward without an attorney?
Yeah.
Okay.
Yeah.
Okay, I'm finding probable cause at this time to hold you until you see your judge next week, okay?
You know, Judge, I was just thinking, not in particular relation to Mr. O'Brien's case, since he doesn't want our office to represent him, but just as a general principle of law, it would seem that a crime that is committed before someone is placed on probation cannot be a allegation against them for violating that probation.
Are you saying that he was, according to this, he's been violated for absconding?
Well,
after he was placed on probation. He didn't
that may
report.
be. That I don't know.
Well, I can't, because he's declined the services of a public defender, and he's representing himself right now. I've let him know that he has a court hearing date next week. Do you want anything? You need any other information, sir?
No, I'm good.
I thought so. Thank you so much, sir. You have a great weekend, and good luck to you next week, okay? Bye-bye. And I'm happy to discuss what you want to discuss later, but he's not your client, and he's fine. Okay. Mr. Carmen?
Mr. Karim? Come on up, sir. He's here present, Judge Amain.
All right. Hello, sir. I have a charge here of resisting officer with violence and a municipal ordinance. I've had an opportunity to review the probable cause affidavit. It appears that there's sufficient information there to warrant a finding of probable cause.
Your Honor, his information has been verified. If the court is inclined to release him to our supervision, then I ask that he be released to pretrial on count one. Count two is an MO, actually a separate case number. So if the court will place him on pretrial on count one.
Really? Okay. Is he interested in pretrial release?
If no ROR is available to him, I believe so, Judge.
I was thinking a pretty hefty bond amount, so I'm a little shocked, but I'm happy to consider the pretrial release if he's willing to.
Let me talk to him what pretrial entails. He may be interested.
Okay. Okay.
Judge, he is interested.
He is interested?
Yes,
All
Judge.
right. Does he have any priors?
Couldn't find anything but traffic related.
All right. Are you all interested in me considering pretrial release, or were you considering something else?
The state would be fine with pretrial release, Your Honor.
Okay. I'm surprised, but I will let you all steer this ship on this one. Sir, I need to make sure that you understand if you're released on pretrial release that you abide by all the conditions of pretrial release. One of those conditions is following the directives of law enforcement officers and people in supervision positions. You need to make sure that you report within a timely fashion. You're going to be drug monitored. I am going to require random drug screens, and any violation of the pretrial conditions, you will be taken back into custody. Do you understand that?
Yes.
Okay, and I'll release him on his own recognizance on the municipal ordinance. All right, and pretrial. All right.
Monday before 12 noon to report to pretrial, correct?
Yes, sir.
Thank you.
All right, good luck to you. Okay. What do we have next? We have Mr. Charles Irving, sorry.
Conti.
Conti? Hello, Mr. Irving.
How you doing?
I'm good, thank you for asking. I have 5 counts pending here. One of them is a traffic matter. The 4 more important matters is possession of MDMA, also known as ecstasy, possession with intent on a cocaine charge, another one, a possession with intent on a cannabis charge, a possession of drug paraphernalia, and disobeying a stop signal. Any argument regarding probable cause?
Yes, Your Honor, I have an argument regarding count 2, the possession of cocaine with intent to deliver. According to the probable cause affidavit, the cocaine was found in Mr. Irving's front right pocket. It was a total amount of 1.3 grams. That is a personal use amount of cocaine. There's no indication in this probable cause affidavit that Mr. Irving was involved in any type of hand-to-hand transaction of any narcotics, either cocaine or cannabis. He is not alleged to have sold any kind of a confidential informant or undercover officer. The allegation that he was in possession with intent to sell is based solely really on the amount of cocaine, and I don't think that that's enough to establish probable cause to say that he was selling it. The marijuana might be different because there are different plastic baggies and so forth, but as far as the cocaine is concerned, I don't believe that there's anything more than a mere possession charge here.
The state's position?
Your Honor, it appears it's based on the amount, and I know the defense counsel says 1.3 is personal use amount. I can't say that it is. I would argue that that's why it's an intent to sell.
Well, unfortunately, if your officer was meaning to let me know that that amount is sufficient to warrant a possession with intent, then he should have made it clearer. But there's no indication here that, which is different, I believe, than some of the other cases you've brought to my attention in the totality of it. But in this, I don't see the intent portion of this, so I'm going to find no probable cause on the intent solely for the cocaine, which could potentially affect his bond amount. What's Mr. Irving's prior background?
Your Honor, I believe that looks like he's out on bond on a possession of firearm by a convicted felon, aggravated assault with a firearm, and a grand theft auto. It's one case number.
Don't say anything, Mr. Irving.
That's okay. They're claiming that you're out on bond on some other cases, that you have some open charges pending, so I want to check and make sure that that's in fact you. So give us a second, okay? What's the case number?
17.
17 what?
7654.
7654.
CF 10A.
Okay. Okay, so let's check. 17. Charles Irving. It's a pretty common name, so let's make sure we got the right person.
No, he is,
What?
Just give me 1 second.
Thank you.
I did the search by his date of birth and it came up with the same one.
There's a warrant. Is there a warrant out for that
Same
one?
thing you
He
said.
was on pretrial on case 17007654 CF10.
Okay.
But apparently what happened, he came in November 5th, technically. And then he was,
They lost my paperwork.
and no, he was attempting to post bond. And bond did not get posted. So at the same time he was trying to post bond, he got an ad charge. When they did the ad charge, they never gave the file back for him to come back for first appearance on 1, 2, 3, 4, and 5.
These cases that he's on today?
That should be the cases he's on today.
Okay.
The other cases, the pretrial warrant cases, and the bond surrenders and everything else, that's not for magistrate. He's on a no bond hold for that. So he's only here for 1 through 5.
I understand that. I'm really having a hard time following you all. I think that the state attorney was trying to let me know that he's picked up a new charge while he's had a pending charge open. Am I correct on that portion of
Yes, Your
what you were
Honor.
telling me? Okay.
I was,
And then the portion of what you're telling me was on the one that he's, on his first case, or are you talking about the case that we're here on today? Because on 7654, there appears to be a warrant flag by his name.
He's in custody on it.
He's in custody on that right now?
Yes, it's not something for magistrate.
I understand it's not something from magistrate, but what I believe that the state attorney's office was trying to bring to my attention is if I was inclined to revoke his bond. What you're telling me, he's
Already in custody on
on
that.
that case. Okay. All right, so I need to leave that case alone. So no matter what I do in this case, he's being held no bond on the other case already?
Yes.
Okay. Okay, and then irrespective of the open case, what is the state recommending? You want me to leave the current bonds in place?
Your Honor, would you like to hear the priors?
Yes.
All right. He has, in addition to the pending case, that he had a trafficking in morphine and opium, 2014. Let's see, battery in 1995, murder second degree 1991, disorderly conduct 91, cocaine possession 91. Looks like mostly traffic after that. Cocaine possession 1990. And marijuana in 1990. I mean, the state would ask that the bond amounts remain in place, even if Your Honor's just gonna find PC for possession of cocaine on count 2.
Anything else from Mr. Reedy?
Your Honor, on the 177654 case, Mr. Irving has private counsel, Bill Cohn. I've been trying to reach him, but I have not had any success. I'd ask the court to reduce the bond on count 2 to $1,000. He's being held, I guess, no bond on the other case in any event.
Thank you all for your presentations. I'm going to go ahead and increase the bond on count 1 to $2,500, $2,500 on count 2, $2,500 on count 3. The drug paraphernalia will remain at $100. Good luck to you, sir. All right, Mr. Dawson. We have a $1,000 capias for Mr. Dawson. Hello, Mr. Dawson. I have a felony capias here for you on a grand theft. Did he miss court and is charged 2? What is this? This is charge number 7.
Count 7.
Count 7. So this is just some additional information on some charges he's already being held on. So,
Your Honor,
sir,
Mr. Dawson's being held no bond on counts 4 through 6.
So, sir, this is just an administrative matter. Really, it's not going to make much of a difference of everything. You have a court hearing already scheduled for Monday. There's a capious felony on a grand theft from case number 1711948 CF10A that carries with it a $1,000 bond. So when you get all the rest of your matters dealt with, if you end up with a bond, this $1,000 will be added to whatever you need to post in order to get out, okay?
I don't understand.
Okay, I'll try one more time. You've already been through magistrates, and you have 6 other charges pending. While you were being processed, they found a capious for a grand theft that you have already pending. And so this is just an administrative matter to pull all of your cases together and make sure you're aware of the fact that there's also a grand theft. You have a right.
May I ask a question?
Of course.
They found a capious?
No, I was wrong. It's an add charge. They're adding a charge of grand theft to your charge from before. What's his other charge right now?
It's added to the burglary.
It's being added to the burglary charge that you have pending.
And does it have something to do with that?
I
don't
know.
understand.
On that same case, sir, you're being held on a $10,000 bond for a burglary. They know information, the possession of cocaine and the possession of drug paraphernalia. Then they charged you with
theft?
the case of grand theft for $1,000.
Okay, so it has to do with the burglary. They dropped the
What
drug.
was grand theft? Is my question.
You want me to tell you what the allegations are that you thought that you stole?
Yes.
Okay, no problem. We can do that. Let me take a look at it. You're set before Judge Backman on Monday morning, and I'll tell you in a moment what they're claiming that you took.
Looks like a stove, a white stove, on October 21st of 2017. A stove, a washing machine, a dryer, and a refrigerator.
Stove, washing, it's a bunch of appliances. Okay?
That's an ad charge?
Well, they had only charged you originally, let me see, what did they originally charge you with? They had only originally charged you with the burglary, possession of cocaine, possession of drug paraphernalia. Even though they can charge you, the burglary itself is all you have to do is enter into the dwelling with the intent to take something. They're saying that you actually took something or attempted to take something which was the appliances that they alleged in here. They never charged you with the grand theft on that case from October. Okay?
Okay. That's it?
That's it.
Yeah, Mr. Gottlieb can explain everything to you, Mr. Dawson.
All right, thank you. Next we have Mr. Christopher Caldwell.
No problem, Your Honor.
Thank you. Okay, Mr. Caldwell. Hi, I have some, looks like ad charges here.
Change of charges.
Change of charges, thank you.
The original charges, the original bonds are count 5, 5,000, count 9, 1,000, count 12, 1,000.
Is the state fine with me keeping those bonds in place? 5, 1, and 1?
That's what they are. Just put them back in place.
All right, yeah, the state's fine with that.
Okay, so, Mr. Caldwell, we just have an administrative matter. When you first came through court, they had you charged with certain things. They've changed some of the names of the charges that they have against you. Specifically, charge number 5, charge number 9, and charge number 12. We're not changing your bond amounts or anything. We just had to fix the names of the crimes that go with those charges, okay?
So what are the new charges?
It went from Number 5 was originally a burglary of an unoccupied structure. They changed it to a burglary of an unoccupied dwelling. On the possession of weapon by an ammo by a convicted felon, they changed it to possession of a weapon. They kept it the same. It looks like they just referenced the case number in which you are a convicted felon in. The same with the burglary of an unoccupied structure. They changed it to a burglary of an unoccupied conveyance. Okay? All right, good luck to you, sir.
Your Honor,
Yes, ma'am.
did you still want to see Dustin Wiggins? He was on the AM docket. You wanted to recall him for PM?
Yes, ma'am.
You need him now or later?
Why was I resetting Mr. Wiggins? I'm sorry. Oh, no, I need to wait, sorry. That's
Okay.
right, thank you. You know, they took the paperwork from me, so I'm gonna need a few minutes. They wouldn't let me keep it. I should have written down the case numbers, I'm sorry. All right, Richard, UCCI.
Mr. Uchi is approaching, Judge, here at Maine.
Morning, Judge, thank you.
Hello, Mr. Uchi. I have a burglary of an unoccupied dwelling and a petty theft that you're being charged with at this time. His capia says structure and the paperwork says dwelling. What is he being charged with?
Judge, while you're reviewing the paperwork regarding the probable cause affidavit of this cases, Mr. Uchi is at a loss as far as the facts. He doesn't know the date of incident or anything like that. Is there any way you can shed some light on information regarding this case?
Absolutely.
When it happened and
We'll review it. We'll review it together. Looks like back at the end of October, specifically October 26th. Looks like at the Seminole Hard Rock Casino, that it's alleged that a victim reported that her wallet was stolen from her hotel room. And that's what this has to do. The wallet contained her credit card, some gift cards, about $7 in money. The wallet was found on the first floor. A review of the video surveillance showed the suspect in the clothing that he was in, walking around the hotel. Went into the restroom, alleged to have committed another burglary and theft. And they claim to have identified him as this gentleman.
So is that a business? Okay.
Okay, and any argument regarding probable cause?
No, Your Honor, it appears there was a videotape of the incident.
All right. What's the
He
state-
does have nothing else holding him.
What's the state's recommendation regarding a bond, and does he have any priors?
Yes, Your Honor, his priors are as follows. They all look like they're out of Miami-Dade. 2015 petty theft, grand theft in 2015, fleeing, eluding, 2010, just without violence, 09, criminal mischief, disorderly intoxication, 09, battery was dropped. That's it.
What kind of a bond are you suggesting I impose?
Your Honor, the state would ask for a $5K bond on count one.
Judge,
Yes,
if
sir.
I can give you a little background, Mr. Uchi. He's been in custody since November 17th. He actually went for the holidays specifically for Thanksgiving to visit his family in New Jersey. He was taken into custody November 17th. He was extradited down here. He resides down here in Fort Lauderdale. He actually rents a room in a house. His monthly rent for that room is about $600. He works part-time. He's a massage therapist. Right now, business isn't so good, so he makes on an average about $150 per week. He's been here residing in South Florida for the past 7 years. He's 36 years old. Judge, he's going to try and contact a friend to post his bond, but he thinks his friend's finances are also quite limited. We'd be asking you, considering this is a business where the alleged burglary took place at, specifically, I guess, at a hotel, we'd be asking you to consider setting a bond on count 1, $1,500, and leaving the standard bond in place on count 2.
First, I don't see how a business makes any difference, and I don't see it as a business. It was hotel rooms that he's alleged to have gone into, which, again, I don't see how any of that makes any difference in my setting a bond. He has priors. That's what I'm taking into consideration, and I'm going to accept the state's offer of $5,000. He'll have a $100 bond on number 2. Good luck to you, sir.
Your Honor, could I ask for no return to the Hard Rock?
Yes, and there is no return to the Hard Rock.
You heard? No return. Thank you.
Next, we have Lou Dempsey.
Judge, Mr. Demacy is here at Maine, Judge. He declined to serve as public defender.
All right, thank you. Hello, sir.
How you doing?
I'm very good, thank you. This is a hold on from Dade County, is that correct?
Yes, ma'am.
Do I don't set a bond on this, do I? Yes, ma'am. Oh, wait a second. This is not making any sense to me. Oh, he has a hold for Dade County, but he also has Broward County cases pending, yes? Okay, sorry. All right, so sir, you have a right to have an attorney represent you at this and all hearings, and if you cannot afford an attorney, I could look into the possibility of appointing a lawyer to represent you. You declined the services of the public defender, so I need to find out from you what you want me to do regarding this matter. You are being charged with a robbery and a false imprisonment. I need to make a determination as to a bond amount for you and whether there's probable cause here. I know you have a hold from Miami-Dade, so what I do or don't do in this case may not affect you as much, but ultimately it's going to have an impact on you. So what do you want me to do regarding you having an attorney? Do you want to represent yourself, or do you want...
Yes.
Okay. You're welcome to represent yourself. However, I just want to make sure you understand all of this is being recorded. So anything you say to me can be used regarding either this case or your case down in Miami, so be careful of what you say. I don't want to talk about the facts of the case. I want to only talk about what kind of bond to impose here, okay?
Okay.
Give me a moment to take a look at the paperwork. I misread it originally. They're alleging that sometime in, looks like June of this year, June 14th, on Pembroke Park Road, that you kept the victim in this case confined in a car against her will. You also made verbal threats to use a gun on the victim, as well as to crash the car into the roadside lake. You also are alleged to be swerving toward other cars and objects in the roadway, and that you made the victim think she would be hurt or killed. While in the car, you pulled the victim's purse away from her and retained possession of the purse and its contents. So based on these allegations, I do find probable cause for the charges of robbery without a weapon or firearm and false imprisonment. you have a hearing with the judge this morning already on this?
Say it again?
Did you have a hearing with the judge yesterday on this already?
No, I didn't get to it because my attorney wasn't there.
Okay, all right. All right, so I'm finding probable cause. Who's your attorney, sir?
My family had an attorney. I don't know the attorney name. I'll try to find out the attorney name.
Okay, well, they're going to reset you in front of Judge McCarthy for this case. In the meantime, what's the state's recommendation regarding a bond on both of these?
Well, Your Honor, I looked up his priors. I see his pending case appears to be aggravated battery of a pregnant victim, assault with a deadly weapon out of Miami-Dade from March of 2016. It says filed anyway as a status. I mean, Your Honor, I would say based on seems similar circumstances, the state would ask for a $25,000 bond, and no victim contact with the victim in this case.
All right, so, sir, at this time, I'm going to go ahead, and your lawyer can talk to Judge McCarthy about changing these bonds right now. You have waived your right to a lawyer for this afternoon's hearing. I'm going to go ahead and impose a $25,000 bond on count 1 and a $25,000 bond on count 2. What's the name of the victim, please?
Your Honor, on the PC, it's blacked out on my copy.
I know, but usually you all can get a...
Let me see I can probably pull it up.
Let me see, I could check in our system.
Sir, you understand that any condition of you being released means that you're not to have any contact with this person. I'm going to find out what her name is. You're not allowed to have any contact with her directly or indirectly. You can't call her, write her, text her, email her. You can't have any of your family members or friends do any of those things either. Do you understand that, sir?
The victim is...
Yes, ma'am. You talking about...
I'm going to tell you her name right now.
Crystal Taylor.
Crystal Taylor, okay?
No problem.
All right, thank you, sir. Good luck to you.
Thank you.
Okay. Anyone left at the main jail I need to take care of?
2 gentlemen, Judge, and not on the regular docket, but on the second look docket. The first gentleman we have is Patrick Roberts. Mr. Patrick Roberts, come on up. I believe he's been in custody since December 3rd on an operating without a valid DL and a possession of an open container. He has a total bond of $25. Judge, I'm assuming he can't afford a post bond, that's why he's still in custody.
I believe he was just county sentenced, because these are the only things holding him.
Was he
You just resolved the case? Okay.
Judge, he's county sentenced till February 10th, 2000.
All right, he's already got a county sentence, so I'm going to delete him from the docket. Next.
No.
Oh, what?
No.
He's county sentenced on something else.
Oh, on something else. Sorry. I thought he resolved these. Okay, sorry. So you want me to resolve these as well?
Yes,
Okay.
Judge, I believe he was sentenced to 60 days already, so he's doing his time on the other. So these would be the only matters left pending.
Okay, sorry.
2690. He's county sentenced, so he has a case.
Do I don't have Mr. Roberts, Patrick Roberts, Oh, here it is. Okay, sorry. All right, it's obviously been a long week. We're almost there. Does he want to resolve the driving license issue, or does he want to deal with that later?
Resolve it.
You know, anything that we resolve today is going to affect your driving license going in the future, including that if it falls within a certain time frame of you being suspended or revoked, that you could have your driver's license continue to be revoked for a long period of time. You're okay with that?
What, the resolve case?
Yep. He says yes, Judge.
Okay. You already had an adjudication withheld on the same exact thing, so I'm going to adjudicate you. You understand that? Yes?
Yes.
Okay. All right, then. Please raise your right hand. Do you solemnly swear a firm testimony you're about to give today is the truth?
Yes.
All right, you put your hand down. You've had the assistance of an attorney. You satisfied with his services?
Yes.
Has anyone threatened you or forced you in any way to plead no contest here today? You know you have 2 cases pending operating without a valid driver's license and an open container matter, that you have the right to have a trial in the matter, and you're giving up your right to a trial today. Is that correct?
Yes.
All right, I'm going to go ahead and understand that you're entering a no contest plea today. Is that correct?
Yes.
I'm going to go ahead and accept your no contest plea as freely and voluntarily entered. I'm going to go ahead and adjudicate you guilty on the operating without a valid driver's license, as well as a possession of open container. I'm going to adjudicate you guilty on both of those, sentence you to time served, and require that you pay any court costs associated with that within 6 months of today's date. Okay, sir?
Thank you.
All right, take care, sir. Yes, ma'am. I'm sorry, what? Hang on, the clerk is telling me something.
Yes, sir.
That's fine. Yes, okay. All right, sorry, we're good on her. I just had an administrative matter. We're good for him. Okay, and then,
The last gentleman, Judge, that we have here at Maine is Mr. Cameron Prouty.
Mr. Prouty, okay. Mr. Prouty. And what do you want me to consider doing here?
Judge, he's been in custody now. He's still in custody. He can't afford to post bond. But from what he informed me is he has a place to live in Boynton Beach. Judge, he's asking you to release him a standard pretrial.
I understand. Is this a gentleman that we had a problem with the other day, indicating to me that he had just an issue? He felt that it was unjust for me to even have to post a bond?
Judge,
He
you
had
probably have a better memory than I do. So
Yep.
I'm probably thinking you're correct. But I believe some people, when they come in here, they're kind of maybe not thinking all that clearly. He's had a better time to reflect these 2 days. He's thinking clearly, and now he's wisely asked me to ask you, Your Honor, to consider pretrial release.
Your Honor, wouldn't give up the roommate's name. I understand sometimes you don't remember the number, but he wouldn't give up not the roommate's name. He said he was unemployed. We have nothing to contact anyone for.
And where in Boynton? And I understand, listen, I'm all about the here and today and forgetting about bridge under the water under the bridge kind of thing and everything. If he's had an opportunity to reassess the circumstances here, and he is now asking me to consider the different options that are available to him, I'm happy to go ahead and address that. Apparently, whatever information he's giving you today is not the same information he was giving before. So let's start from scratch. Where does he live?
Boynton Beach, Florida.
And who do you live with?
I live with my roommate. His name is Andy.
Do you know what Andy's last name is?
Berg. B-E-R-G.
And how long have you lived there, sir?
I've lived there a year and 3 months.
Okay.
So last year, September, I moved in there.
Okay. And what's the address there, please?
908 South Chippewa Circle. I'll spell that. C-H-I-P-P-E-W-A Circle. Boynton Beach, Florida. 33436.
I'm sorry, what, Patrice? Is that a house or an apartment?
It's an apartment.
And your apartment number?
908.
You understand that if I release you on any type of pretrial release that you'll be required to test regularly? I'm not saying I'm doing it. I'm just trying to make sure you understand what the requirements are here before I go any further.
Yes, ma'am.
That'll include random drug screens. That'll include potentially blowing for use of alcohol, and you're gonna have to stay away from any alcohol or drugs. You able to do that?
Yes, ma'am.
I remember one of my concerns was just the whole circumstance and the information that the whole totality of what occurred in this probable cause affidavit. I remember this gentleman in some of the hearing, but I don't remember the actual factual scenario, so I need to pull this case again in order for me to make a decision. What's the state's position regarding either lowering his bond or placing him on pretrial release?
Your Honor, I couldn't find any, anything that wasn't, traffic. Do you?
I didn't see anything.
No. I mean, I wouldn't have an objection to pretrial release.
What was the case? I'm sorry, what's the case number on this one here?
I have the facts, want it?
17.
029-462.
MU.
Yes, DUI sub MU.
Oh, I didn't know that. That's new since my days in criminal. I learn all sorts of stuff. Since he lives out of county, I'd want him tested weekly. Okay. I don't know. Am I gonna regret this, Mr. Powdy?
You will not.
Because, I have to explain to you, because you live out of county, you're the one that's gonna have to do all the work to stay in communication with the pretrial people and to make the arrangements to have weekly drug testing. You understand that?
Yes, yes, ma'am.
Okay, I don't know if you have anything in your system right now, but the allegations have to do with cannabis, so if you do have anything in your system right now, those levels are gonna have to drop, and I don't wanna see one iota of you driving recklessly or driving under the influence, and I want you to test weekly and report weekly. You understand that?
Yes, ma'am.
Anything else you want to let me know about your attitude the other day?
I sincerely apologize for my behavior that night.
That's it. No, don't.
Not that night. I'm talking about my interaction with you the other day.
Judge, from what it's worth, I mean, I'm speaking to him now, completely different person. I mean, he's eloquent, he's lucid, he knows what.
We lost your mic.
He seems very remorseful.
Okay. All right, sir. The best that I can tell you right here, if you get yourself into any more trouble, you'll be held no bond. So this is all on you. Okay?
Understand.
I'll release him to pretrial release. He'll have to report what, on Monday? Monday morning. You need to be back in Broward County to report before noon. Okay? And I want him tested on Monday morning. So you better not drink or use any drugs over the weekend because they'll be in your system. You understand that?
Yes, ma'am.
Okay.
Thank you, Judge.
Thank you.
Okay. Well, that's fine. We'll have to take a level. All right. I think that all that's left then is Mr. Wiggins at the, oh no, we have one more second look someplace too?
Well, Ramon Gonzalez is on the docket, Judge. We had him this morning. He's still a medical loan.
Okay, fine. And so all that's left is the gentleman, was he at North Broward? Where was Mr. Wiggins?
North Broward, yeah.
Okay, I'm gonna go off he can stand there for a moment. I'm gonna go off the record for just a moment. Unfortunately, I didn't write down his case numbers, and the clerk's office took the paperwork, so I need to read his paperwork real quick. So, Mr. Wiggins, give me a minute, and I'll consider whether I want to resolve your cases from this morning, okay?
Okay. Judge, just want to say goodbye.
Oh, right, okay. Mr. Romero, I'm so sorry. I usually remember to say goodbye. I apologize. It was a pleasure working with you this week. Same to you. Have a great weekend and a good holiday season, okay?
You too as well.
All right, bye. I'm going to go off the record while I look at this paperwork. To deal with Mr. Wiggins. Where's Mr. Wiggins? We have Mr. Wiggins. North Broward. They think we were done?
You're like, why is he telling me?
How can we get the folks at North Broward to bring me back Mr. Wiggins? No one's answering. All right, we'll go off the record again. All right. Yeah, I saw them in the background. Thank you. Hi, Mr. Wiggins. Someone needs to mute his mic for me, please. Oh, you figured.
Hey, how you doing?
I'm very good. That was smart of you to figure out how to do that. So, Mr. Wiggins, you had asked me to consider resolving your matters here today.
Yes.
Okay, you understand that you have a right to have an attorney represent you at this and all hearings. You also have a right to go forward on these matters to trial and to have the state bring witnesses to prove their allegations against you. You understand that you would be giving up all those rights. You understand that?
Yes, ma'am. Is there any way I can get like pre-trial, like I could have like my sister or somebody here with me to understand, like, cause I really like I'm not trying to lie or anything or like create a story or something, but like the way I was seeing,
Okay, wait. There's one of two options we can do here today. If you want to resolve these matters today, and if you want to talk to the lawyer after you hear this, I'll let you talk to him on the phone. I would consider pre-trial if you want to take these cases to trial, or if you want to resolve them today with adjudications. That means you'll have these on your record. I'm willing to adjudicate you, time serve you on these as well. So do you want
Okay, so I'll take the adjudication.
You sure?
Yes, ma'am.
Okay, all
Would
right.
I be able to get out today?
Yes, sir.
Okay, so I'll take the adjudication.
Okay, not withhold, they're adjudications, okay?
Okay, I know it'll be there. I
Okay,
understand.
all right. Please raise your right hand. Do you solemnly swear affirm testimony you're about to give is the truth?
Yes, ma'am.
Okay, you can put your hand down. A couple of things that you did wrong here that's going to be part of your plea, even though I'm going to be adjudicating time serve you, is you're not allowed to go back to marshals anymore, and you cannot, absolutely without a doubt, you are not permitted to drive without a valid driver's license. You understand that?
Okay, they're valid. I understand that.
You have one now, a valid driver's license now? Okay. Is me pleading him on this no valid DL now going to affect his driver's license in the future?
It effect on his driver's license in the future. If he drives on a suspended license, if he gets 3 within 5 years, he could lose his license for 5 years.
Well, you're sure you have a valid one now?
Yes, ma'am.
I'll withhold on that one, since now you have a real one. Okay?
Yes.
Okay, all right. Am I forcing you or threatening you in any way to plead no contest here today?
No, ma'am, not at all.
You understand all the rights that you're giving up here this afternoon?
Yes, I do.
Am I forcing you or threatening you in any way to plead no contest to these matters?
No, not at all.
Okay, very good then. I'm going to go ahead and accept your no contest plea as freely and voluntarily entered. I'm going to go ahead and adjudicate you on the petty theft, and I'm going to withhold adjudication on the driving on a operating without a valid driver's license. And what else does he have? I'm sorry, what?
This merchant without violence.
And then the other, what was that? That one was the Marshalls. And what was the other place? There was Marshalls twice. I think there was Marshalls twice. Walmart? Okay. Sir, you can't take stuff that doesn't belong to you. We got that clear?
I understand that.
Okay,
yes,
I
I don't do that anymore.
Okay.
I found a job now.
Okay. All right. Well, then I'm not even going to require that as part of your plea. These were a long time ago. I'm hoping that you've changed your ways and that this isn't going to be an issue going forward in the future, okay?
Yes, ma'am.
So I'm giving you adjudications on everything except for the driver's license. Now, listen to me. Because there's 2 theft cases here, you steal anything else in the future, and they could upcharge you to felonies. You understand that?
Yes, ma'am. I won't steal anymore.
All right. Good luck to you, sir. I'm adjudicating you. I'm sending to you to time served on all of these. Good luck to you.
Thank you.
All right. Take care.
You too.
Okay.